Let's think about what Henry Sumner Maine means by from status to contract by looking at family law, especially Roman family law, because it's in family law that Maine sees the best example of his idea of a set of rights and obligations that derive from one's status, one's place in the community, rather than through one's conscious, voluntary choices. Contract. Our world, our relationships are deeply structured by contract. I'm here because of a series of contracts that are made between different parties. Students pay the university, university pays me. You could actually go back and trace signatures, that actual physical contracts in many of the cases. Our world is full of contracts. Every interaction we have every day is ultimately grounded in some kind of contract, with some important exceptions. And the most notable exception in our world, and the one that would make the most sense in these terms, is to think of the parent-child relationship. The parent-child relationship is grounded in status. It's rooted in a natural relationship that is not voluntary. You don't choose your parents, and your parents don't choose you. It's not a voluntary relationship. And the way that we structure it in our society is organized around the concept of minority and majority. In our world, there's a magic day in your life when you turn 18 years old. And what happens to you on that day when you're 18? You are effectively free of parental tutelage. You can buy cigarettes, you can serve in the war, you can vote for office. You can do any number of things, because when you cross that magic line in our world, you're considered to have capacity. You have maturity, and you've attained majority. And even though there's obviously nothing absolutely magical about that 18th birthday, some people are a little more mature than others on that day, it's a convention that we have that recognizes that people reach a certain kind of capacity in which they're ready to be full, freely contracting agents and members of society. When you're 15, you can't sign certain kinds of contracts. You can't go buy a house. You can't make a mortgage when you're 15. You need certain kinds of parental consent because you're in the power of your parents. Move back now to the days of the Roman Empire. There isn't a concept of minority and majority. There isn't a magic day when you're an 18-year-old, full, freely voluntary agent of society. Instead, Roman family relations, indeed Roman personal relations, are organized according to status and family. Think about the foundations of Roman family law. The central organizing concept of the Roman family is what is known as patria potestas, that is, paternal power, the power of a father. It is a severe and, in some ways, by our standards, extreme kind of power. The Romans have a sort of mythology that the father has the power of life and death, although, in fact, Roman parents don't necessarily have the right to execute their children. It's part of the mythology. So great is paternal power. Paternal power is an exceptionally strong legal power, and it is unending without an act of death or will. What this means is that a Roman father has patria potestas over his dependents, that is his children and his slaves, until either he dies or he chooses to emancipate them, even a child. Now, think of what this means. It means that there's no moment at which a child is free of his father's power. If he's a 5-year-old, he's in patria potestas. If he's a 15-year-old, he's in patria potestas. If he's 25 years old, he's in patria potestas. If he's 50 years old and his father is alive and has not emancipated him, he is in the power of his father. That means that, for instance, he can't legally own property. His father can give him property to use. He can have a house or a farm to live on, but he can't legally own it if his father has power over him, has potestas. So an individual can be, by our standards, a full adult, but have severely incapacitated legal rights, inability to use property, to make certain kinds of contracts without the will of the father. This is a vestige of the fact that the Romans think of their society as organized into households under the power of these kinds of fathers with extreme legal rights. By the time of the Roman Empire, most Roman citizens marry in a fashion that's called sine manu. It's a way of saying that the wife doesn't come into the direct power of her husband. Because in fact, in Roman society, wives remain under the power, under the patria potestas of their father. And so a wife is, of course, married to her husband, but is also still profoundly under the power of her fatherly family, of her birth family. And this is maintained in the way Roman property is structured in terms of Roman family law. In the Roman Empire, the spouses in a marriage don't have conjugal property. They don't have shared property the way that we think of it. The Roman marriage, in fact, has two different property funds. And so a wife who brings a dowry into a marriage is still technically in control of that property. The husband has his property. Now, of course, they may effectively, on a day-to-day basis, use their shared property, but it remains two distinct kinds of property. Why is this? It's because if the wife dies without having children to pass on that property to, the Romans don't want that property passing to the husband, into his male line. That property, the dowry, will revert back to the male family of the wife. It also makes divorce relatively simple from a legal perspective in Roman society because there isn't any shared property to be divided up. There's simply two different funds, and if spouses part ways, they can simply take their funds with them. And in fact, the Roman law of divorce is an extremely liberal divorce regime in which divorce is relatively quite easy to get by either of the partners by unilateral consent. And so Roman law structures family relationships around this idea of the male line and his power. It has important effects in the arena of tutelage. Quite often, Roman fathers don't live to be 100 with their sons 70 years old in their power. In fact, Roman society is a high mortality society, and quite often fathers die. What happens when a father dies? Even if the mother is living, the children will go under the tutelage of a male relative. And as this law develops over the course of Roman society, it in fact becomes more effectively based around contract. This is a good example of Main's thesis. The Roman father has the ability to appoint a tutor by testament. He can choose, and by an agreement, by an act of will, can choose who the tutor to his sons will be. If no tutor is appointed by will, then by default, the nearest male relative, a mother, cannot be the guardian of her own children because the children have to be in the control of a male, and a male from the father's line. So a magistrate will appoint a tutor from the male line if there isn't one. And so this is an illustration of the way that Roman law structures rights and obligations around a kind of status relationship. Relationships that arise out of how one is born and the relationships that are already existing. Not acts of will, not contracts, but status. Out of relationships that are somehow given in the structure of society itself.